गुड मॉर्निंग स्टूडेंट्स। आज के इस वीडियो ट्यूटोरियल में हम इंडियन सिटीजनशिप के बारे में बात करेंगे। सबसे पहले इंट्रोडक्शन के बारे में बात करते हैं। सबसे पहले ये जानते हैं कि हमारा जो इंडियन कॉन्स्टिट्यूशन है उसका जो पार्ट सेकंड है वो सिटीजनशिप के टॉपिक से डील करता है and it includes articles between 5 to 11 which deal with the topic of citizenship यानी कि भारतीय नागरिकता। सिटीजनशिप के लिए जो भारत में कानून है उसे इंडियन सिटीजनशिप एक्ट 1955 के नाम से जाना जाता है। इस एक्ट को 1986, 1992, 2003 और 2005 में अमेंड किया गया। यहाँ एक बात इम्पोर्टेंट है कि प्रेसिडेंट ऑफ इंडिया इज नोन एज अ फर्स्ट सिटीजन ऑफ इंडिया। ब्रीफ में जान लेते हैं आर्टिकल्स 5 to 11 के बारे में। आर्टिकल 5 है, इट डील्स विद सिटीजनशिप एट कमेंसमेंट ऑफ द कॉन्स्टिट्यूशन। आर्टिकल 6 deals with rights of citizenship of certain persons who have migrated to India from Pakistan. Article 7 deals with rights of citizenship of certain migrants to Pakistan. So Article 6 deals with persons citizenship who have migrated to India from Pakistan, and Article 7 is rights of citizenship of persons who are migrated to Pakistan, and Article 8 deals with rights of citizenship of certain persons of Indian origin living outside India. Article 9, it deals with persons voluntarily acquiring citizenship of a foreign state not to be the citizenship of India. Article 10 deals with continuance of the rights of citizenship. Article 11 deals with Parliament to regulate the right of citizenship by law. यानी हमारी पार्लियामेंट के पास ये पावर है कि वो सिटीजनशिप के रिगार्डिंग कोई भी लॉ बना सकती है और इस लॉ को रेगुलेट करती है। सबसे पहले बात करते हैं जो कि बहुत ही इम्पोर्टेंट क्वेश्चन है, दैट इज एक्विजिशन ऑफ इंडियन सिटीजनशिप, यानी कि भारतीय नागरिकता को कैसे एक्वायर किया जा सकता है और लिया जा सकता है। सिटीजनशिप एक्ट जो 1955 है वो 5 वेज और तरीके बताता है जिसके द्वारा एनी पर्सन कैन एक्वायर इंडियन सिटीजनशिप। सो दीज 5 मेथड्स ऑफ एक्विजिशन of Indian citizenship are: first is by birth, second is by descent, third is by registration, fourth is by naturalization, and fifth is by incorporation of territories. इन सभी के बारे में हम थोड़ा सा डिटेल में जानेंगे। सबसे पहले बात करते हैं हाउ Indian citizenship can be acquired by birth. What is the meaning? It means persons who were born between 26th of January 1950 to 1st July 1987. So any person born in India in between these durations is a citizen of India by birth. However, between 1st July 1987 and 3rd December 2004, a person is a citizen of India if either parent was a citizen of India at the time of the birth. But after 3rd December 2004, there is another condition, means any person born is considered citizenship of India only if both of the parents are citizens of India, or if one parent is a citizen of India and the other is not an illegal migrant at the time of their birth. So we can see that here in this period, if either of the parent was a citizen of India at the time of the birth of any person. But after 3rd December, any person born is considered citizen of India if both of parents are citizen of India. So the citizenship laws are becoming tougher and tougher. Second is by descent. It means persons who are born outside India on or after 26th January 1950 but before 10th December 1992. If their father was a citizen of India at the time of their birth, so it means citizenship by descent. Second is between 10th December 1992 to 3rd December 2004. If a person is born outside India on or after these dates but before 3rd December 2004, he will be considered a citizen of India if either of their parents is a citizen of India at the time of their birth. And after 3rd December 2004, the condition is changed. It means unless their birth is registered at an Indian diplomatic mission within 1 year of the date of birth, and minor should not hold passport of any other country. So this is the meaning of by descent. Third is by registration. So what is the meaning of citizenship by registration? It means a person of Indian origin who is ordinarily resident in India for 7 years before making an application. So a person who is living in India is a resident of India for 7 years, so he can make an application for registration of Indian citizenship. Second, a person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. So he can also make an application. Third is minor children of persons who are citizens of India. They can acquire Indian citizenship by registration. Next is by naturalization. It means Indian citizenship can be acquired by a foreigner, but he should not be an illegal migrant. The condition is the person who is ordinarily resident in India for 12 years, and in these 12 years throughout the period of 12 months immediately preceding the date of application. So before the application, the person moves the application, before that he should be continuously residing in India for a period of 12 months. And for 11 years in total aggregate in the 14 years preceding the 12 months. So before 12 months, total of 11 years in the aggregate in 14 years. So this is the condition for acquiring citizenship by naturalization. And the last is by incorporation of territories. It means if India acquires any new territory, all residents of that new territory will be considered as citizen of India from the date the India acquires that territory. Now we come on to the loss of citizenship and how Indian citizenship can be lost. There are 3 methods. First is renunciation, second is by termination, third is by deprivation. First is renunciation. Section 8 of the Citizenship Act 1955 deals with loss of citizenship by renunciation. It means if an adult makes a declaration of renunciation of Indian citizenship, he or she loses the Indian citizenship. Second, also any minor child of that person also loses Indian citizenship from the date of renunciation. But the point is that minor child can acquire again Indian citizenship or can apply for Indian citizenship when he becomes major. Second is by termination. It is covered in section 9 of the Citizenship Act. It means when an Indian citizen voluntarily acquires the citizenship of another country, so he automatically there is a termination of Indian citizenship. Third is by deprivation. It means the central government may compulsorily terminate citizenship of any person if the citizenship is acquired by fraud, or if a person shows disloyalty to the Constitution of India. Third, if a person communicate or trade unlawfully with the enemy country, and if a person gets imprisonment in any country for 2 years or more, or within 5 years after citizenship by naturalization or registration. The last is if a citizen is residing in any other country for more than 7 years continuously. So in these conditions the central government can deprive a person of his Indian citizenship. Now we come on to the next topic, that is Overseas Citizenship of India scheme. What is this scheme? This scheme was introduced in year 2005 after making some amendment in the Citizenship Act 1955. So this OCI scheme was introduced in year 2005. This question can be asked like OCI scheme was introduced in which year? So we have to remember that in year 2005. However, this scheme was started in year 2006 during Pravasi Bharatiya Divas celebration in Hyderabad. According to this scheme, any person may be considered eligible for Overseas Citizenship of India card by or OCI card by the central government if the person makes any application and fulfills certain conditions. What are those conditions? These are the conditions for OCI card. First is, if any person was a citizen of India on 26th January 1950 or at any time thereafter, or if a person belonged to a territory that became part of India after 15th August 1947. Third is, the person is the child or grandchild of a person described above. He or she never been a citizen of Pakistan or Bangladesh, and she has not had any involvement in serious offences like drug trafficking, moral turpitude, terrorist activities, or anything leading to imprisonment of more than a year, and applicant's country of citizenship allows dual citizenship. In these conditions, if person fulfills these conditions, he is eligible for acquiring the OCI card. Now, what are the benefits of this OCI card? Following are the benefits. Person who holds OCI card, he enjoys all the rights and privileges available to non-resident Indians on a parity basis for economic, financial and educational matters. So in these matters he acquires rights and privileges which are available to non-resident Indians or NRIs, but he has no right to investment in agriculture and plantation properties, and he also cannot hold public office. The other benefit is he can visit the country at any time for any length of time and for any purpose. These are some of the benefits of OCI card. However, there are certain rights which are not available to OCI card holders, like right to vote, right to hold the office of President, Vice President, Judges of the Supreme Court and High Court, Member of Lok Sabha, Member of Rajya Sabha, Legislative Assembly or Legislative Council, and appointment to public services. So these benefits are not available to OCI card holders. आज के इस वीडियो ट्यूटोरियल में इतना ही। हमारे और फ्री वीडियो ट्यूटोरियल्स के बारे में आप हमारी वेबसाइट gkindiavideos.com पर लॉगिन कर सकते हैं। अगर आपको हमारी वेबसाइट, हमारे वीडियो ट्यूटोरियल्स पसंद आते हैं तो आप हमारी वेबसाइट को सोशल मीडिया फेसबुक ट्विटर पर ज़रूर शेयर कीजिए। धन्यवाद।